Ladies and gentlemen, very good welcome, and also big thanks to Thomas Hoeren for inviting me for this short presentation on copyright, specifically in UK law. And in this presentation, I'm going to give a rough overview, actually, over the Copyright Designs and Patents Act. Basically, what does the law protect? Why does the law protect certain efforts? We're going to look briefly at economic rights. We're going to look at moral rights. We're going to look at, in particular, defenses. And overall, the question how UK law deals or could deal after Brexit with instances such as music sampling, transformative uses, i.e., or the questions that have actually arisen in the past, also before the European Court of Justice, so decisions on music sampling, Palm, etc. And in order to provide a broader framework in the context of how does English law actually develop notions of property and how does it deal with the imbalance between property and freedom of communication. We're also going to look broadly at how the law has developed in related causes of actions that can be complementary to copyright protection, in particular as regards the incremental development of UK law, perhaps due to a form of a publicity right, an absolute monopolistic right in one's personality. UK copyright law is, of course, very, very different from the author's rights approaches that we find in continental Europe and that we find in Germany in particular. There are many deviations in terms of approaches to copyright and its basic rationales, and these deviations or divergences also have an impact, of course, on some of the more fundamental legal principles. Where do you find copyright law? Predominantly, you'll find it in the Copyright Designs and Patents Act, 1988. And this act is the latest, if you like, statutory embodiment of copyright. There had been copyright acts in 1956 and 1911 and earlier in the year 19th century. This act in particular regulates copyright. It does regulate also designs, unregistered design rights under UK law, and there are also a few provisions dealing with patents, but in relation to patents, the main statutory act is the Patents Act 1977, so it doesn't really deal with patents. What is copyright? It's defined as a statutory property right. And that basically means it is a right to exclude. So in that sense, it gives, of course, some kind of monopoly. Secondly, what is protected? And here we have the first and fundamental deviation from German or French law. Copyright law in the UK protects literary, dramatic, musical, and artistic works, i.e. primary works of authorship. And at the same time, it also protects the so-called neighboring rights, such as rights in sound recordings, broadcasters' rights, rights in films, i.e. motion pictures, and other assorted related or neighboring rights. As you can see, the Act does not really differentiate. And the Act does not distinguish between primary and secondary classes of works, such as under the German Authors' Right Act, by providing a specific chapter, for example, on individual neighboring rights. It's all the same, basically. And the other thing that you will note is that the Act does not specify any originality standard. So in other words, it follows from the description of works and subject matter that there will be protection. And that can have certain unintended consequences of overprotection, as we shall see. So what does a judge have to do? It can be quite tricky for a judge to define what is protected and what is not protected. And the first guidance is given actually in the description of works. And that's what the CDPA is actually saying, that copyright subsists in the following descriptions of works. Some works, or the description of some works, is sometimes moral. For example, a literary work is a work that can be written, spoken, or sung, and that includes a table or compilation, and indeed also includes computer programs. In other cases, in particular artistic works, there is only a kind of enumeration of subspecies, if you like, of works that will attract copyright protection. And this can be tricky. The first slide that you see, or the first image that you see on the slide, of course, is the famous creation records case. This case was about the notion of what a work is. The background is, what you see here is the final record cover of Oasis' Be Here Now. However, whilst they were shooting that particular scene, they kept rearranging the items that you see here, for example, the grandfather clock and the motorbike, etc. And whilst they were doing that, someone took a photograph, and that photograph was published subsequently. So there was a question. If we look at artistic works, of course, can it be said that this is, for example, a graphic work, a sculpture? Is it a collage? Maybe. But it could even be something else. It could be a kind of compilation. It could even be a database. Provided that, for example, a database might include an arrangement of physical items itself. If you're interested, have a look at that decision. There is a lengthy discussion actually on all types of works and their definition in case law, which highlights actually the difficulties that you have in a system where the originality threshold is more or less absent. I'm coming to that right now. Originality is usually, in all Anglo-American copyright systems, described as skill and labor or the sweat of the brow. That is a minimal requirement. So it is, what is protected is not the author. It is not the personality of the author that emanates through a particular work. The emphasis is on the work itself, and the work is understood as being a commercial asset to which a property right applies. So it is a right that is predominantly given to exploiters. The reason you will very, very often find references to John Locke and his labor theory, who basically said that you need property to be free. And that is very often applied to intellectual property, although John Locke never said anything about intellectual property itself. But nevertheless, the basic approach is to have a system that is initially founded upon notions of a utilitarian approach. It has nothing to do as such with personality rights. And as we shall see, we're going to talk about moral rights or personality rights under copyright in a moment. It didn't really fit the system as such. Why is it so difficult sometimes to categorize subject matter? And I have another example here. The underlying reason is perhaps the difference or the divergences between case law and statutory law and the role of courts. With copyright, we are talking about statutory law, so it's written in the statute, of course. And that means it's a representation of Parliament's will. So Parliament steps in, perhaps, to correct a certain element of previous case law. In that way, courts, of course, need to respect that parliamentary will, and they do that typically by way of an extremely literal interpretation. And of course, that can lead to all sorts of issues. Again, you see here a rather fascinating case about the props from the Star Wars movie series. Yeah. So you see a stormtrooper helmet. And in this case, the court decided, well, this is not a sculpture. Why? Well, they said a sculpture, that is something that you make for artistic reasons. So it cannot be functional. Whereas, of course, the stormtrooper helmets were presumed to be functional in that sense because they were to be used in the movies, because they would convey a particular atmosphere. The background to that decision, of course, is that the court tried perhaps to limit the impact of copyright on existing design rights, which are, of course, much shorter in turn, 25 years versus 70 years, and which also give more restricted economic rights. But there are other examples where this whole question of, how do we qualify works, how do we categorize works, can become intricate. And there have been debates in the past, and I'm not going to go into too much detail here. For example, of course, on computer programs, before they were added to the notion of literary works, websites. What is a website? Is it a graphic work? Is it a database? Is it both, etc.? Multimedia works, that's a discussion that has more or less ended, but which was a really prevailing debate maybe 20 years ago. And a lot of books and articles have been written on the proper categorization of multimedia works, whatever that might be. Yeah, it's works that will necessarily combine different categories of works. And computer programs and computer games. In particular, is a computer game, is it just the expression of the underlying computer program? Is it a film, etc., etc.? What is originality? This is right now quite a complex question because on the one hand, of course, European harmonization has not as such affected the originality standard under UK law. In fact, you will not find anything referring to, for example, creativity, like the German Authors' Right Act does, in terms of requiring a personal intellectual creation. Quite simply, the CDPA does not refer to originality in any sense. So this is really still judge-made law. In European law, in European secondary law, i.e. where the law actually talks about an intellectual creation, a personal intellectual creation, computer programs, databases, and original photographs. This has also not been implemented in the UK. The Court of Justice said in this decision in InfoPack, perhaps 11 little works could be, sufficient for the purpose of a general and autonomous European standard of originality. It is quite open. The example that you see here, where on the left you see, I think that's the original, and the other is the alleged copy. Originality actually is still very low, and in this case, the courts in the UK actually said, well, there is enough creativity. So basically, the standard of originality is more or less the same. So let's move on to the economic rights, and unsurprisingly, the UK Act contains more or less the same economic rights that you will also find in German or French copyright law and in most other copyright jurisdictions. So there is a right of reproduction, there is a right of distribution, there is a right of adaptation and communication to the Communication to the public includes the rights of a public performance, certain rights related to broadcasting, and also to cabling and satellites, etc., etc., and the making available right. So, of course, you find the whole European acquis in terms of economic rights under UK law, and actually European law hasn't really led to any changes, with the exception of the new making available right to the public. So here the law is actually highly influenced, of course, by the case law of the European Court of Justice, and more recently it has been decided in the June decision by the Court of Appeals that UK courts, as far as copyright law is concerned, will follow the, let's say, guidance of the European Court of Justice, despite Brexit. Okay, so it's not going to be a complete break in this regard. There are moral rights in Germany known as personality rights, and these rights are completely disenfranchised from the other rights. So there is a separate chapter, more or less at the back of the CVPA, that deals with moral rights. And the reason is, of course, moral rights do not fit into a system that is predominantly based on protecting concepts of investment. So they are alien concepts in a sense, and they had to be implemented and introduced basically because there were international conventions such as